Hello there, and welcome to the Disability Law Show. We're back at it for another week. John Scholes, simply the host, and all the brains of the operation right over there. Tamar, Agopian, reachable anytime. Try email first. That's a good one. help@disabilityrights.ca. If you want to back that up with a phone call, no problem. 1-855-821-5900 just to chat. Consultations are free as well, so have no fear with picking up a phone, calling Tamar and her team, and getting any information you need about this topic of disability and dealing with that insurer as well. Main topic later in the show: 3 common mistakes to avoid when applying for LTD. That is a huge topic off the top. We always cover that every few months, so we'll do it again this time round. We'll get to some emails, possibly some phone calls from our radio show. It's a whole bucket of good stuff tomorrow, but we always start off with a case of the day or a week that was success story. I know this one's kind of personal this week. What do you got going on?
Yeah, it's a personal one because I'm in the process of getting retained for this particular client. And so I wanted to highlight a situation. It's a bit unique in the sense that it's an area that we practice in, but not as often as we would see the disability claims. It's a critical illness policy that he's reached out to us about. And so how is this different for our viewers? You would have seen an insurance plan that probably came with maybe your group disability benefits. Maybe you've got an individual plan that you've reached out for and you're paying a premium for. But essentially, a critical illness disability policy will cover you for a one-time payment if you have a listed critical illness. And so the topic for this week is cancer, the big C word. Tends to be quite common in the sense of we see a lot of denials for these critical illness claims, John, because the policies are getting trickier and trickier. So this is why I highlight my potential client situation, because in these policies now, you'll have 2, 3, 4 pages of critical illnesses that they will cover for. So you're thinking, great, I'm going to get this policy, hopefully something terrible doesn't happen and I don't need to actually use this policy, but in the event that it does, then at least I can rely on this one-time payment to supplement whatever otherwise income that I'm going to be out of as I deal with my illness. The challenge with cancer in particular is that because there are stages of cancer, there are types of cells that are considered cancerous, whether in some instances it is not. These policies are riddled with a number of exclusions, okay? And so I highlight this one because the exclusion that the insurance company applied in this potential individual's claim was to say that his claim was a recurrence. Now, we talk about recurrences in other disability plans all the time, and so the idea being that if this is something that you had before, and you got better, and then you had it again, essentially, you may or may not be covered. In the context of critical illness, and in this particular individual situation, he actually was diagnosed with prostate cancer a number of years ago. It was considered stage 1 for those who know what that is. And the advice he received, because he was relatively young, was the doctor said, look, let's take a wait-and-see approach. Let's not treat the cancer just yet. Let's see what happens to it. You can live with it. It's not a problem. And it hasn't grown. It hasn't spread. We were going to take a wait-and-see. Fast forward, he obtains this critical illness policy. A number of years go by, and he's starting to get symptoms again. And so he returns to his doctor, and doctor now says, okay, now it's a stage 2 or 3. I think now is the time to treat it. And treatment will include likely surgical removal or addressing it surgically, and potentially radiation or chemotherapy. Why this has become significant is because at that point then he initiates the critical illness claim. So he makes an application, makes the claim, and insurance company says, it's a recurrence. It's a recurrence. And so he comes to us, John, and he says, Tamar, I don't understand how could it be a recurrence when I've always had the illness. And I say to John Doe, I totally agree with you. It is absolutely not a recurrence. So we talked it through because there are some technicalities. I coordinated a conversation with his oncologist, his actual doctor that's going to treat the cancer, who of course confirmed this is not a recurrence, confirmed that the insurance company had this wrong, and also said this: I see this all the time, you should fight it.
The doctor
said this, John. This is why I wanted to feature it in our show, because now the doctors are seeing what we're seeing all the time, which is if the insurance company can find a technical reason to deny your claim, and this applies to disability claims, critical illness claims, whatever it may be, they are going to take advantage of doing that so they don't have to pay you. And so why does this become even more important is because even the doctor's recommending you're going to need a lawyer to fight this. You need the lawyer to argue the wordsmithing around why this exclusion doesn't apply. And so for our viewers, the courts have made it very clear that if there is an exclusion or a limitation that the insurance company is relying upon to deny your claim, the legal onus is actually on the insurance company to prove that it applies in your situation. Now, I don't expect our viewers to know this, but this is why it becomes even more important to get the right representation. Hire the lawyer, fight this, because if your doctor's saying this doesn't sound right, use the smell test. If this doesn't smell right, it means it's probably not right. And so I like this case for a whole host of reasons, but of course we're in the process of being retained, and maybe I'll provide an update in a couple more shows as to how this played out.
I'm thinking of this whole oncology thing doesn't work out for this doctor. He should be a disability lawyer. He just nailed it right off the top.
Absolutely,
right?
But what does that tell you when you see that the treatment providers are now giving this advice to their patients to say, I've seen this before. I have seen other patients be successful when the insurance companies have aggressively denied otherwise valid disability claims or valid critical illness claims. And he's a young father. He's got a family. He's going to be without income for a number of months. He needs this policy. He needs the payment of this policy. And the way he came to us, even in the conversations that we were having, he said, look, I'm not trying to pull a wool over anyone. I really thought this is a legitimate disability claim. And I assured him, much like his own doctors, that this is absolutely correct. There's nothing wrong with hiring a lawyer to fight this against the insurance company because you're owed the compensation. But the starting point is that phone call and having a conversation with us, and let's see if we can help you.
Another website you can use anytime, disabilitylawyer.ca, pocketdisabilitylawyer.ca. That's where that's at. Tamar, you're a big fan of this. This is something you guys at the firm put together a few months ago, I would say. Pretty handy tool. How does it work? It
is a handy tool. I mean, it came from, the Pocket Employment Lawyer. It's an add-on to that. And so what are we trying to do here? We're trying to push out as much information that's easy for people to use as possible. Similar tool that way. It's a drop-down menu. You can put in some information, yes or no questions, and you can just assess, do I have a claim here? Do I need to speak to a lawyer? But if you don't want to, close the browser. It's anonymous. We're none the wiser. But at least it's that starting point of understanding, what are my legal rights? What can I do in my situation if I've got a basis for a claim? Should I not be contacting the firm for a free consultation?
Disabilityrights.ca, there's a website for you. Among the other things you can learn and reach out to Tamar and her team from that website. You'll also be able to find a radio station pretty much across the country where we do a radio show. It's either half hour or an hour weekly. We're all over the place. So the kings and queens of media is what we like to refer ourselves to. Anyway, the shows are good. Get a lot of great phone calls from the shows, and we like to play them back here again for an educational purpose. So I think we have them lined up here. Tamar, let's have a listen to it.
Company said, we have no accommodations for you. They found out that I had a degenerative disc in my neck. You're now short-term and then long-term disability. So I was on long-term for a year and a half. I got a registered letter from the company, which said, we're processing your resignation as of this date, which cut off my benefits as well.
Here's that crossover again between the employment side and the disability side, right?
Absolutely, John. And so this is why we're so well suited in dealing with these kinds of situations, because that interplay exists so often, but it shouldn't. It shouldn't. So for anyone listening to this caller's information, what does he tell us? Degenerative disc disease, physical condition, employer didn't want to accommodate. I suspect they pushed him off onto short-term and long-term because it makes that easier for the employer not having to deal with the hard work of the duty to accommodate. Yep. And then you get a disability insurer who's saying, we're kind of good. We don't want to wait out this process. We don't want you to have to go through what I suspect is the change of definition that's coming up, because most of these policies after the 2-year mark will have a tougher test to continue to qualify for benefits. And so they avoid that by having that cutoff at the 1.5-year mark, or avoiding as well altogether the idea of having to get the disability insurer to put you back into the work setting where they have to go through that accommodation process again. So there's a lot to unpack here for our viewers. And so here's a couple of things to keep in mind. Your employer has some duties, the disability insurer has some duties. Yes, they are connected. Yes, that I don't want to say collude, but they will have conversations and emails and communications during the life of your claim when you're on disability. And they, both sides of it, know exactly how a claim like this is likely going to play out, which is accommodations could be costly or difficult, and long-term disability benefits are going to be costly for the disability insurer. So instead what they do is they wedge these poor individuals into a situation where they have nowhere to turn, or at least feel that way, where they can't return back to work, and they've got a disability insurer who's not going to support them. What's the answer? The answer is the legal claim. The legal claim, first and foremost, in respect of the disability insurer, if they've cut you off prematurely, and secondly, potentially an employment claim for the employer's duty for failing to accommodate. Now look, we've got the Employment Law Show and lots of resources on the employment side, so I encourage people to think about that and the accommodation and getting some advice around that. But as it relates to the disability claim, you do have some rights. And if the insurance company in that process is being vigorous, and then you've got your employer who terminates you through the midst of all of that, that is a big problem for the insurance company and the employer. And so myself and a few members of our team as well do both areas of law that we specialize in at our firm, both employment law and disability law. And these are the kinds of phone calls, John, that, they get my blood boiling, obviously. I see a number of, bases for which we could assert a legal right. But people have to make that step, make that effort, and move that forward so that we can get the compensation that they're entitled to, because it's a problem for the employer and a problem for the disability insurer.
Lots more to go. 3 common mistakes to avoid when applying for LTD. That is on the other side of the break as we continue the Disability Law Show. Stay with us. We're coming right back.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
Okay, welcome back. Disability Law Show as we continue on here. Always feel free to reach out to Tamar by phone. The consultations, by the way, are free. It may not be something of that level. It could be a simple chat. It's all the same number, 1-855-821-5900. Email help@disabilityrights.ca. Our main topic, as I mentioned before the break, we'll get into now. 3 common mistakes to avoid when applying for LTD. Number 1, Tamar, not providing all necessary information about your disability or your medical condition. That's probably not uncommon, I would imagine.
It's not uncommon, I think, because people feel as though they should focus on the one issue that actually put them off work.
Right.
But oftentimes when I've seen disability claimants, it's not just one issue, right? There could be things that have been progressing for some time. There could be other factors at play. And so I always encourage people, comprehensive information when you're applying for disability benefits is critical, because there are actually 3 forms that need to be completed when you apply for a long-term disability. It's a form that you complete as a claimant, plan member statement, some kind of statement that you make. It's a standard form, 3, 4, 5 pages. Then there's a second form that has to be completed by your primary treating doctor, again, explaining when your disability began, what are the symptoms, what are the limitations, what recommendations there are in terms of your prognosis and so on. And then there's a third form actually that comes from your employer. And usually that gets coordinated between the insurer and the employer directly to get that form. But you should know that the disability insurer will not start the process of reviewing a claim unless all 3 forms are made available. And when they look at it, the adjuster will take it and look at the package, John, and they'll say, oh, your doctor says that you've got a history of depression. Can we get some more records? And so sometimes I see the disability insurer pending the disability application. So they won't even review it. They'll just park it and say, we need more information from your own doctor so we can look at it all together. And so this is why you want to get ahead of that. If you've got some complexity with your disability claim, if there's elements of it, perhaps you've got physical components, maybe some mental health, and like I said, maybe it's a progressive disability. All of that information should be made available to the insurance company right out of the gates so that away you go, package is ready, you can get a prompt decision on whether or not your claim is going to be approved.
Second thing mistake you want to avoid when applying for that LTD is, oh, this one's custom made for me. Missing deadlines and submitting forms and supporting documents. Never done that before. Maybe not in this arena, but yeah, there you go. Really important though.
It is really important because insurance companies and adjusters in particular, they're obsessed with the paperwork. They need the paperwork, as I said, before you get even out of the gates of having your claim even reviewed. And they need the justification from your own team around why is it that you're off, what is the basis for the disability claim, and so on. And so the deadline is in particular, though, I get my back up a little bit because those deadlines are somewhat arbitrary. They're important, but they're arbitrary. So what do I mean by that is that the adjuster will tell you, look, I need an updated report in 2 weeks, but it might take you a month to see your doctor to get that updated report. And so I try and get people to understand, look, don't stress about it. Advise your adjuster, look, this is when my next appointment is with my doctor or my specialist. This is when I expect to receive this information. I'll provide it when I can. Here's my update to you in an email or something like that. That's all fair, but recognize that the insurance adjuster's job is to justify in their file that they've got necessary medical information to release that disability benefit to you month over month. This is why there's that, as I said, obsession around getting that paperwork and the importance around actually getting it to the adjuster. This is tough though, John, because I know for a fact our medical system is completely strapped. There are so many family doctors who are overwhelmed with the process. Many of them don't even get paid to fill out forms. This can be a real challenge for our viewers to say, look, but I've asked my doctor 4 times for this documentation. I know I've got to get it in. I think the real takeaway is that work with your practitioners, work with your adjuster. If it's coming, and that's okay. Do the best that you can. One example is if you've got more than one practitioner, maybe you hedge. Maybe this month you get a report from the therapist, and next month you get a report from the family doctor, and vice versa. So at least there is that information that's available to the adjuster to continue to review your claim, continue to release that benefit, and so that you continue getting that income.
There is a third one. This is the third. And if you're wondering why Tamar knows so much about this, somebody used to work for disability insurers, so you've got the inside scoop.
Guilty.
You've been on the dark side, right?
Guilty as charged.
Number 3 is this, focusing only on the diagnosis without showing how it impacts your daily life, right?
So obsession around the paperwork, obsession around function, okay? Insurance companies and adjusters are very much clinging to what is it that you can do even if you've got a diagnosis or you don't have a diagnosis or you've got these number of symptoms. This is why the medical information is so critical, is because you really do want those dots connected. What is your occupation? What are those health issues, and what are you prevented from doing? And not only as a claimant do you want to get that information yourself over to your insurance company, you want that medical endorsement as well, because it becomes really, really important when the insurance adjuster is invariably going to look at this and say, okay, I think we want to cut this off. Maybe we don't want to approve it. They're going to cherry pick information. They're going to say there isn't enough information. Any excuse under the sun to find a basis to either cut off, and this is where they dig. And so if they can say, well, you've got the function to go grocery shopping or go to the park with your kiddos, it must therefore mean that your back pain isn't bad enough, your depression isn't bad enough. And that's what I'm trying to avoid for people here when we try and give these common ways to try and get the claim approved, get the benefits continuing to be approved, is getting all of that information, comprehensive information, all of the details over to the insurance company so that it avoids, the hopes that people will continue getting that, benefit paid. But if they don't and they get cut off, and it's a silly decision, which it oftentimes is, then I do hope they reach out to us to get the help that they need so we can challenge the insurer on these bases.
Lots more to go. We always wrap up the last segment of the show with viewer emails and questions. We'll get to that on the other side of the break. We'll take that now and continue with more of the Disability Law Show. Stay tuned.
People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.
All right, we are back. Disability Law Show. Got a few minutes to go. Let's bounce over to an email. Tamar, by the way, you want to reach out through email and phone 1-855-821-5900, help@disabilityrights.ca. It's going to be Noah. First up, says, guys, I'm a unionized city employee and suffered a heart attack last year due to stress. Despite my doctor's advice that I wasn't ready, I was pressured to return to work. I tried, but found my physical and mental health quickly deteriorated. Now, the disability insurer has refused to reinstate my benefits, but said I could try appealing. Do I have any other options here?
Where do I begin, John?
Right.
Where do I begin? Because I picked up on the first part of Noah's email saying to us he's a unionized city employee. Mm-hmm. We see this a lot, right? We practice across the country. There's unionized employees across the country. And I've actually been told by some callers that unions are actually telling them that you actually have to appeal. And so I think what's important here, number one, is that that's not necessarily your only option, even if you're a unionized employee. We can actually help people like Noah. I'll look at the collective agreement, make sure that's the case, but the vast majority of unionized people can actually pursue their right to disability benefits with the help of a disability lawyer, someone like myself, someone on our team, in the context of a legal claim. It's efficient. We use the legal claims to our greatest advantage to get the compensation that people are owed. And in situations like Noah, where the insurance company has pressure to return to work, is refusing to reinstate benefits, this is all the makings of a very good legal claim, because I suspect that the insurance company is not doing right by Noah. And so here's what I'm concerned about, John, is that what's the pressure of the return to work when he describes to us that he's got physical limitations and mental health limitations? Is all the information being made available to the insurance company when his claim is being evaluated? I'd want to see the medical file. And if it is, then why is it that the insurance company is refusing to reinstate the benefits? I think that the pressure to return back to work is a signal to me that the adjusters looked at this and said, you can be treated for your mental health or your physical symptoms and still work. You can probably get back to a job that maybe the employer can accommodate you to. All of that are, excuses that I've seen in claims files, letters that I've seen denying benefits to people like Noah. But if his doctors are still recommending that he's not capable of working, that's full stop. That's the end of the conversation. That is what crystallizes Noah's right to the disability benefit. That is what puts the insurer in hot water. And I can assure you that when we start that legal claim, and we're not dancing around on the appeal, we're actually asserting that legal claim, we are putting that pressure on the insurer to say, are you actually going to stand up before a judge in a court and make this argument? Because I can guarantee you it's not going to fly. And I think you owe compensation to people like Noah, people like our clients, and let's see this resolve. And we do it in a matter of months. But the appeal just drains individuals, right? It just runs them down, runs down that clock, and there's no end, right? You can appeal and, oh, this is the last appeal, send us more information. To what end? Whereas the legal claim, there are time frames, there's finality, we put the pressure on, and we get results for our clients.
And the client no longer deals with the insurance company.
Correct.
Nice.
And they don't have to buckle to that pressure, right? That pressure goes away. They focus on their recovery. They can deal with their doctors, and we will take care of dealing with the insurance company, and we will get the compensation they deserve.
Another resource for you anytime, mydisabilityquestions.com. Mydisabilityquestions.com. It's free, it's anonymous, lay them on. They'll get answered anyway, but they might appear on a future show. For this week, Tamar, it is Emma writing in, says, my insurer asked me to fill out a form about my work experience and skills and submit a resume. I've been on LTD for almost 6 months with a herniated disc, causing extreme pain from my lower back down to my foot. While I've had an MRI and finally spoke to a neurosurgeon, I'm still awaiting treatment. Can I be pressured into working before I've recovered?
You can be pressured, Emma, but should you be pressured is a different question, right? And so again, I don't want individuals to feel that they have to buckle under that pressure when their doctors are advising they should not be working. This is actually a medical question, not a legal one. Insurance companies shouldn't be telling you what to do. Quite frankly, I shouldn't be telling you what to do, except to say, if you're being cut off for this reason, Emma, please call us. We will start that legal claim. But more to the point, I think that you see this a lot when you've got physical disabilities where it's a long time to get the treatment that's required. You can see that she needed an MRI. Then she's got to wait for the neurosurgeon. There's time that it takes for all of these steps to be put in place to assess what kind of treatment Emma needs. And John, insurance companies are impatient. They don't want to keep paying you while you're waiting 9-10 months to see the neurosurgeon. They want to say that you have that capacity to work now, today, with all of your limitations, with all of your health issues, because that serves them. That means they don't have to pay you if you buckle under that pressure to actually return. So full circle back. If your doctors are recommending that you stay off work, stay off work. Insurance company gets impatient, cuts you off, you have options. You can start that legal claim. And I suspect we'll probably have it resolved right around the time where I can demonstrate, hey, by the way, the neurosurgeon is saying she needs surgery. Right?
The thing that tips me off, and I think the big hint is here when they're asking for experience, skills, and submit a resume, they're sniffing around looking for a different job for Emma to do, right?
Fair point, because in that context, the insurance company is likely getting ready to review whether or not Emma's going to meet the next test under the policy. Most of these policies have 2 tests to qualify. The first part is whether she can go back to her own job, own occupation. And after 2 years of benefits or 24 months, the test is there anything Emma can do? Anything for which she's got the education, training, and experience to do, which is exactly the form that they've asked her to complete. So absolutely that signals that the insurance company is reviewing this and thinking, we don't want her past the 2-year mark. We want to be able to demonstrate that even with her current condition, even with all of the investigation that still needs to happen with her severe back pain, that there is a level of function that allows her perhaps to do an office job, perhaps work from home, perhaps answer some phones and do that. And in the context of that, they will therefore probe in their decision-making around whether or not they're going to meet the test past that 2-year mark by asking claimants to fill out these kinds of forms. Now look, for our viewers, I don't want you to be worried about why your adjuster is actually asking you to submit this form. It's fair game. You should cooperate in their review. You know, we get that question a lot. You know, do I have to supply this information, Tamar? Yes, you should, but be careful in the sense that understand that this information could potentially be used for them to identify that you've got another job that you can do. And so it becomes critical for your own medical team to continue to endorse that at your current level, at your current function, with no treatment at all, that you still are not capable of working in any setting. Let's not leave this gray here, because that is what the insurance company will latch on to try and justify closing Emma's claim.
And, you know, quickly, with that other job they're potentially sniffing around for may not be at the full pay of what you're used to, right?
That's
commensurate income, right?
That's exactly right. So the commensurate wage is something that we look at, which is typically tied to what your LTD benefit is, so roughly 2/3 of what you're making. So they make that threshold very high to meet past that 2-year mark for a reason, because that's usually when they want to try and cut off these claims and not have to pay until you're 65.
Emma, thank you so much for reaching out. And that question again through mydisabilityquestions.com. They get answered all the time by Tamar and the team outside of the TV show, but yours may make it on here. But it's always informative and educational, so we appreciate that. And same goes for Noah writing through the email as well. I'll give you some contact information before we fly out of here for another week. The phone call, free consultations. Remember that. That's a very important part. 1-855-821-5900. help@disabilityrights.ca. Again, help@disabilityrights.ca. Thank you so much for joining us. Reach out anytime to Tamar and her team. They're always ready to talk to you. And we'll catch you next time right here on the Disability Law Show.